Morning. Please be seated. This is the time set for argument in the case of Cr1 Agard versus Roger G. Lundvet. I've probably massacred both of those names, and I apologize. Each side will have 20 minutes within which to present their arguments this morning. Appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your time in that regard. We've read the briefs. We've been through the record. We've conferenced the case. We're familiar with the facts and the issues raised. So please take that in consideration as you make your arguments here this morning. We are recording these proceedings, both audio and video. So as you approach the podium, please identify yourself and your client for us and for anyone who wishes to review the recording later. The video recording will eventually be available on YouTube for future reference. With that, appellant may proceed.
Good morning, Your Honors. Thank you. May it please the Court. I'm Paul Riggs, and I represent Roger Lundvet, who is present. He is the former husband in this matter, and we filed this appeal for various reasons. I just want to point out at the onset, it should be noted that it's highly desirable legal objective that cases be decided on their merits, that any doubts should be resolved in favor of the party seeking to set aside the default judgment. I just want to emphasize that. This is my first opportunity before an oral argument since moot court and law school at U of A 28 years ago or something like that. So this is a great opportunity. We have opportunities sometimes in family court to do oral argument of that type, but nothing where I'm peppered back and forth, and I expect to be peppered a little bit. Hopefully you'll be gentle with those pepperings. Nevertheless, I believe this is a void default decree. It's void because it failed to meet notice requirements. There was the issues that I think were void was it's required pursuant to Rule 44 specifically to give notice to an attorney if they're represented and also to the party. It has that in that language in Rule 44, A1, and then A and B in that section.
Mr. Riggs, ask you a question about how the default rules work. But let me make sure we're all on the same page about the facts. As I understand what happened here is that counsel for Ms. Agard applied for entry of a default, and the clerk accepted that. And then within the 10-day period, your client, through counsel, moved to dismiss the proceeding. And so that was an appearance, and so under the rules, 44, the entry of default then did not become effective. Then eventually the court denied the motion to dismiss. And then there's kind of a period of inaction. At that point, did counsel or did Ms. Agard need to then move for entry of default before she could then go to the next step, which would be to pursue a default judgment? What happens?
In normal circumstances, no. But in this case, there was a judge that actually denied the application.
All right. So what you've got is a motion that was filed seeking certain relief, and that motion was denied.
It was denied, correct.
Your position is then that issue is off the table.
It's off the table. It can be reapplied. I'm not saying you can't.
That's my question. Does she have to reapply?
I do believe you have to reapply because it doesn't resurrect itself on its own. I don't think it revives itself on its own because, again, you saw in our reply brief, dismissal or denial are ultimately the same thing, except for a denial is even stronger as to that moment. So when you're talking about that, it's time. Okay, now it's denied. I think sometime in July. So they could reapply sometime in July. after 10 more days or 30 more days, whatever they want to, they could reapply, and they did not.
But let me make sure I understand. Reapply for the entry of a default.
They could apply anew. Reapply is not the right word.
Right,
but
they could
apply
pursue
anew.
it again.
I believe they could.
Okay.
And he filed a motion. If you notice in the record, he filed a motion, and his motion asked for us to have a default hearing, but even that motion didn't follow the notice requirements.
Now, are you talking about the attorney filed a motion?
The attorney filed a new motion.
Okay.
Opposing counsel filed a new motion, and in that new motion, he said, give us a status conference or give us a default hearing. And that was on the 30th of July, if I recall correctly.
Counsel, is it fair to say that in this kind of this lineal issue of this application for entry default, there's the application is denied, and the next thing that happens is there's a court request for status conference or default hearing?
That's what opposing counsel did do. Point
being, there's no additional application, there's no withdrawing of the court's order denying the entry of default.
Correct.
All right.
And even if the court wanted to interpret the motion as being a new application, it didn't follow requirements as an application, which is required notice to be both the attorney, who he did have counsel at that time, and the party. They're both notices required in that circumstance. I believe in that circumstance the decree itself is void, the judgment itself.
Now, on that point, when I went and reviewed the record as on the motion to set aside, the motion to vacate, did you preserve the argument that the judgment was void?
I did in my motion. I said, pursuant to Rule 85, it was void. It was a statement that was made. I believe it was preserved in that regard. But further, void judgments are void always. Mm-hmm. I don't think didn't look hard before I got here, but in my mind, I don't know if there is a statute of limitations in which to appeal a void judgment ever. I don't know if that's true or not, but it doesn't make sense to me that you could ever not have the right to appeal a void judgment. It's not logic. If it's void, it's void. The time frame in which to make an appeal, I don't think should ever lapse regarding a void judgment. Again, he raised the issue of issue preclusion. I don't think issue preclusion is here because there was no opposing litigation. I don't think that really is the issue. I think it was a void judgment that should be addressed right away, or that needs to be addressed. Again, I'll go to the second argument, unless you want to continue on this issue. But the other point that I want to make is he said he substantially complied with the rules, but substantial it needs to be absolute regarding when you do an application for default, not just substantial. It has to be absolute. It has to be full. It has to be complete, and that did not take place in this circumstance. My second point, and then we focused on that a little bit, probably more so in my motion to set aside, is that a decree needs to mirror the petition. As you know, historically, the petition for legal separation was filed, and all she asked was general relief. And when I say general, divide community property, award us our sole and separate property, those types of things. And I get that. It needs to mirror it, though. I notice opposing counsel, appellees, points out that my client had ample time to respond, to file a response, etc. They had ample time to amend. They had plenty of time to amend. They had plenty of time to disclose. They had plenty of opportunities to there was a response. It wasn't a response, but there was a motion to dismiss. They knew there was opposing counsel. That could have triggered a lot of disclosure, if need be, pursuant to Rule 49 and Family Rules of Procedure, which did not take place.
So there was no disclosure?
No disclosure on their end to either side, really.
Thank you.
No disclosure whatsoever as to, okay, here's the property, here's what I'm going to make a claim for the property. No disclosure ever.
So doesn't the mirror image rule that you've alluded to only apply when a party is entitled to obtain a default judgment by motion? Then there has to be clear notice in the petition or the complaint that what the relief the plaintiff was seeking. But when a party pursues a default judgment through a hearing, the rule on its face says if, in order to enable the court to enter judgment or to carry it into effect, it is necessary to take an account or to determine the relief to be granted, So there can be some general pleading, and that's why you have a hearing.
Well, but you can't substantially change the character of the nature of property at a default hearing. And that's what happened. They changed the character, the nature of that property by saying, oh, suddenly this property that appellant owns becomes ours, and we divide it in half.
Well, here, didn't Ms. Agard say, basically in her complaint or her petition, award the separate property to the spouses and divide the community property? I mean, it was general, but that was obviously what was going to happen.
I understand,
Right.
but when a defendant believes that property is his sole and separate property, when he has facts, which we can't litigate here, when he has disclaimer deeds or those types of things saying this is my property, even though it was acquired during the marriage and wife signed off on a disclaimer deed and it's mine, it can't change its character, and yet
But that's an evidentiary issue that could have been.
that could not have been done in a default hearing, and that.
Well, I'm sorry, I'm not sure that's correct.
Well-
And many times, a party will allow for a default, and then they will litigate over the relief. They're not going to litigate over liability, but they'll litigate over the relief, and then they can duke it out as to whether property is separate or property is community, I thought.
That is correct, and that did take place, and I can't remember the case that was cited in here. That it talks about that, whether you can go for the special damages of the $12,000 or other relief. But she didn't ask for that specific piece of property. She didn't mention any property specifically as to what she wanted to declare as community or not.
Counsel, I have a question for you along the line of Judge Norris, and I'd like you to address this for us, if you would. The issue of equity is stated throughout the original petition, seeking equitable relief, seeking equitable division, correct?
Correct.
All right. How was equity determined at this default hearing? Was there testimony as to values?
No.
For instance, there were 2 bank accounts apparently.
No, there's 3 pieces of property.
Well, I just
Yeah. Okay. Oh, you're
go
giving
with, go with me on this.
Okay. All right.
There were apparently 2 bank accounts. The court ordered 1 bank account to go to the petitioner, 1 bank account to go to the respondent, correct? Now, 1-to-1, that might be equitable. Was there testimony as to what was in those accounts?
No.
All right. So when we're talking about the division of the assets, there was no determination that they were equitably divided. They were simply numerically divided, if you will. 1 went here and 1 went there.
They were just ordered to be sold,
In regard to the property.
cashed out. They were ordered to be cashed out and divided.
In regard to the real property, was there any request for deeds, any request for history of ownership or payment histories?
No, there was no notice of those things.
So what was the process by which it was determined that equity determined that they must be each sold and divided?
None, other than she says we bought them while we were married. That's all she said. We bought them when we were married. That's all she makes a declaration of. And it was a 6-year marriage. Second marriage, obviously. It says we bought him when we were married. He's a farmer in Iowa, and his farm buys land. Again, if we had a chance to have an evidentiary hearing, it would show that how it was acquired and how it was signed away. But we don't have that opportunity here because it was defaulted. My client said, he opposed it. He says, it's my property. And yet it was disregarded. Again, he's defaulted, but he still said it's my property. And he said it's my family's estate. He talked about it that way. That's the way he understood it to be all this time. Again, I do believe, even in an application when you testify, it has to mirror. It has to mirror, unless you have it has to mirror what you plead. Otherwise, because it's assumed, you're accepting what they claim. He's assuming it's sole and separate property when he's served. Let's say he didn't even respond. All of a sudden, she changes the vernacular to be, this is our property, when she never declared it before. And it's to be sold when it was never asked for before. Those are the 2 things. It be our property and it be sold. Those are 2 things that were never in the petition. And I think that goes beyond the pale. Again, I'm going to reserve the rest of my time unless you have further questions you'd like to ask me at this time.
Thank you, counsel.
Thank you.
Good morning. May it please the court. I'm Richard Fergine, and I am the attorney for the appellee wife, Pearl Lagarde, formerly Pearl Lundvent, who is present in the court today. My first point is that the only issue I believe it's properly before the court today is, does the relief granted in the decree exceed the relief sought in the petition? Because we're here on appeal from the Rule 85C motion and not on appeal from the decree itself. In husband's motion, the only ground he raised for relief from judgment was that the judgment was void because the relief granted exceeded the relief requested. There was no mention of misconduct as there was in his appellate brief. There was no mention of notice as there was in his appellate brief. None of the arguments made in the appellate brief were made in the rule other than the one about exceeding the amount requested in the petition. And therefore, I think all those other issues should be summarily dismissed. And that is supported by the court's decision in Air Freight via Evergreen Air Center, that if issues are not raised in this motion, that he is not allowed to raise them on appeal.
That's not a void case, as I recall, that's not a case that concerns a void judgment, is it?
I don't believe it is, Your Honor, no.
Well, I thought we had cases in Arizona that if a judgment is void, it truly is void, which means then the invalidity of the judgment can be raised on appeal even if it was not raised as an argument in the motion to vacate.
But, Your Honor, here the court's not reviewing a statute or a rule or the application. They're reviewing the judgment, the discretion. I think abuse of discretion is a standard of review here. They're reviewing to see if the judge applied the rule correctly.
Well, an entry of default if it's void, it has no effect. Zippo. And I thought my question is, I think we have case law in Arizona that when you have a void judgment, even as, for example, let's say under the rule here, the parties move to set aside the judgment because of a mistake. That's not a void judgment. Okay? That's a different ground. But then on appeal, counsel determines, wait, I raised the wrong argument, or I didn't raise all of the arguments, and this judgment is not only should have been set aside because of a mistake, but it's void. Counsel can raise the voidness issue on appeal. It hasn't waived it because the judgment is void. If it is in fact void. I mean, it's an issue that is always preserved.
Right. Okay. And I would, first of all, a couple things I want to address is I know counsel wasn't at the default hearing. I was, and I was also representing Ms. Lagarde during the trial. We did make disclosure to the other side. We did request discovery. This is a case where wife filed her petition in January, and filed and served her petition January 17th. We never received a response. On February 28th, husband filed a motion to dismiss, and ultimately on April 7th, that motion was denied. He was represented until August 27th, and from the time of that denial of that motion to dismiss, all the way through August 11th, which is the date upon which the hearing on default was set, he never filed a response. He never filed any kind of pleading whatsoever, even though he was represented by counsel the entire time. As a matter of fact, if he had problems with the motion to set a default hearing, why didn't he file a response to that? If he didn't like the judge's order setting the hearing, why didn't he ask for the court to reconsider that?
But the argument, and this is a question I asked counsel, was, well, that's true. It was like radio silence. At that point, procedurally, didn't your client need to then reapply and go through the appropriate steps under Rule 44, which the first step would have been to apply for entry of a default?
Well, the default, the application was entered as the rule provides when it was accepted by
Yes,
the
and
clerk.
then the 10 days and all of the procedural, but that didn't happen. You didn't do that.
Right, the 10 days were stayed because he did file the motion to dismiss. However, when the commissioner dismissed the application, she referred it to the trial court, so it didn't seem as though she meant it to be dispositive of the case or the issue. She denied it, but referred it to the trial court for further proceedings, at which time we filed our motion to set hearing. And when the court granted that motion and set a hearing, I think that revived the application.
But forgive me, I didn't see any cases, any rule, any statute, any authority that says somehow that resurrects the application for a default, which in fact was, under the rule, had become ineffective because of counsel's appearance. So do you have an authority, you have some cases or something that says, yep, that in fact happened?
Not that says it resurrects it, but the motion itself serves every function that the application does, other than giving the 10 days to respond. It identifies the party, it gives a date of filing, it gives proof of service, it informs the defendant of the intent to seek default. The only thing it doesn't do is say you have 10 days to respond. Well, before the hearing, he actually had 65 days after that order to respond.
I understand that. The 10 days was included in our rules several years ago in order to avoid these precise problems, to give parties an opportunity to wake up and litigate on the merits. And even if I were to assume the motion to set a default hearing maybe was the functional equivalent of an application for entry of a default, the 10 days is a meaningful right here.
Well, I think that substantial compliance is enough. If you would like to analogize with, for instance, their misconduct argument, when there is misconduct, it's not enough that that be proved by clear and convincing evidence, but it also had to have had some interfered with the party's ability to defend their action. In this case, I see no prejudice done to the defendant, and considering that he didn't respond to the petition, he didn't file a response after the initial application was filed, he didn't file a response after the motion to dismiss was denied, he didn't file a response to our motion to set the hearing, and he didn't file a response once the court set the hearing. Even the most general response would have cured his default. For him to now argue, geez, if he had just sent me a second notice of default, that response would have been forthcoming, I think is disingenuous.
How many times, counsel, do you have to cure a default? I mean, to respond to a default issue? They respond to it with their motion to dismiss, right? You put in your application for entry of default.
Right.
Within the 10 days, they filed a motion to dismiss. That's their appearance. Right. Now, do they need to, say, every 8 days continue to file something so that we know they're in the action? Or having done that, does that not stop the default process, given that they've appeared in the case?
I don't think it does, Your Honor, because they still didn't respond to the petition once that motion was denied.
Did anybody go back to the, and I'm, you see a lot of variance on this kind of stuff through the course of practice. Did anybody ever go to the court and say, or did anybody ever send them a letter and say, we're going to give you 10 days to get your answer in. If you don't, we're going to file a second order asking for the court to enter the default. Did you ever do that?
No, we filed that application for default, I believe, in February, and it wasn't ruled upon until April. And as soon as that was referred to the trial court, that's when we filed our motion to the trial court requesting the default hearing.
Why did you file a motion requesting a status conference or default hearing? If you were sure that you were ready to go with the default hearing, what was the purpose of making it optional with a status conference or default hearing? I think it was the other way around, actually, default hearing or status conference.
Right. I guess just for that reason, to give the court the option. And I think if the court had set a status conference, we'd have a different situation here. Then I think that husband would be correct in saying, look, the court just set the status hearing. I'm not informed that you intend to proceed with default. The court doesn't appear ready to proceed with default. But in the present case, the court did set that hearing.
So is the court setting the hearing dispositive as to whether or not a default was appropriate?
Yes, and something that I think is important too is husband did have his day in court. Even though he didn't file a motion pursuant to the rule that would allow him, the court, that would command the court to take investigation and allow him to participate, he just filed an ex parte continuance request that was denied. But despite the fact that he failed to file that motion, the court allowed him to appear by telephone. The court allowed him to give a testimony. The court did do an investigation that the topic of whether or not the property was sole and separate or community was discussed. Both parties were allowed to testify as to the character of that property. And as you know, it's presumed that marital property is community unless you can show by clear and convincing evidence it is not, and husband failed to meet that burden. But he did have his day in court. He was heard despite his claims that he didn't have notice. He appeared at the hearing and he gave testimony, and he made his claim that property was sole and separate. And of course, as far as presenting any evidence, he never made any disclosure, so he had no documentary evidence to present. And so they had nothing to go on other than his testimony, but he was allowed to appear and testify at that hearing. And they decided he hadn't met his burden. They determined that because of that, the presumption of community property governed, and they divided the land.
You say that he had the opportunity to present his evidence. What put him on notice before the default hearing that he would need to provide evidence in regard to the parcels of property?
Well, I don't know that anything puts any party on notice that they need to present evidence.
Isn't that the purpose of disclosure and discovery?
Well, and like I said, we took part in disclosure and discovery.
But my point is, you say that he had the opportunity to present evidence to support his positions. But he didn't even know it was a position, based upon my review of the record. He didn't even know that in contest was going to be the issue of the 3 parcels until the default hearing. So how would he have defended that?
That's not my recollection.
Okay, tell me what happened then.
I believe that he was aware prior to the hearing that the division of the property was what we were seeking. And I can't say that unequivocally. That's just my recollection that he was.
For the record, you're talking about the real property.
Correct, the real property, yes. Yes, and that was really the only property that was acquired by the parties during the marriage. And I think if I can quickly address this idea that it wasn't, that it exceeded that requested, there's no rule, no statute requiring to specifically list the property you believe to be community or sole and separate. In fact, the Lamparella decision says you don't have to do that. And it would almost be impractical, or if not impossible, to do that, because discovery takes place after the petition. A lot of times we don't know the scope and the value of assets and obligations until after discovery, and that's why most practitioners, I would guess Mr. Riggs often does what we did in our petition, that's just divide the community property and obligations equitably. To require us to do otherwise, like I said, would be problematic, if not impossible. And certainly there is no rule or law that requires any more than that. And to claim that an equal division is not equitable, I think Toth stands for the proposition that that's only the case under very unusual circumstances. Here the parties got some real property during their marriage. It was divided equally, and I don't know how you can say that was not divided equitably. Certainly it didn't exceed the amount requested because no amount was requested, and I don't think it was different in kind because real property is always, well, quite often part of any divorce, so I think it falls within the division of dividing the property equitably.
How do we know that the bank accounts that were given one to each party were divided equitably? The money. How do we know that the money of the marital estate was divided equitably?
Honestly, Your Honor, I don't recall that testimony. That was never raised in Mr. Riggs' appellate brief, and I wasn't prepared to address that issue. I don't know that it wasn't, to be honest. I don't know that
that it was not?
Yeah, I don't know that it was. It may have been raised. There may have been testimony to that effect.
What effect?
That the accounts were equal. My recollection is this: the accounts were sold in separate property. That's my recollection. I don't recall that anyone claimed that those were community property. The parties were elderly when they got married, and as we stated in our brief, the only property of any significance that was acquired during the marriage was the real property. Both parties had separate bank accounts when they entered into the marriage, and they kept those. So based upon my recollection, those were separate accounts that were just confirmed to each of the parties. I don't believe that they were community property. There, it was a marriage of short duration. They were elderly and had their own sole and separate property entering the marriage, and it was my understanding that they kept everything separate. And that's why we, in our brief, argued that the only property at issue was the real property.
Counsel, can I ask you a clarification? I think I understood you to say that even though the court specifically denied your application for entry of default, that because it was in the same ruling, it was transferred to a different division of the court, you assumed it was okay to proceed and filed a request for a default hearing or a status conference. And is it your position that that pleading is the functional equivalent of asking for application for an entry of default?
I think that the motion served the same purpose, as I said, and put put husband on notice of our intent to seek default. And I also think that when the commissioner sent it to the trial court for further proceedings, it was my understanding that that denial was pending the decision by the trial court, that matter was referred to them. And when they set the hearing, it revived the application. If it was dispositive of the issue, I see no reason to refer the matter to the trial court. So it was our understanding, I'm gonna deny this application. Now it's going to go to the trial court, and that judge can do with it as she pleases. And in this case, she decided that a default hearing was appropriate.
I mean, you certainly recognize that when the rules were changed some years ago, one of the critical components of the new rule was that in a notice for entry of default, that the party to be default is given express warning, an opportunity. They have 10 days to take action to forestall that. And there was no such advice in your request for a status conference or default hearing, was there?
No, that was the one thing that the motion did not list, but as I said, 65 days passed before the hearing.
I understand that, but there was no express direction to the party against whom you were seeking relief that they had a finite period of time within which to file a responsive pleading.
That is correct.
Thank you.
I will clarify something I've been asking about, and I was mistaken about its placement in the default decree. In fact, the bank accounts do say, I believe, that each bank account was in the name of the individual party.
Right, and that was my recollection, Your Honor.
I was actually thinking about the vehicles. The vehicles were just distributed. Whatever vehicle they had, they got to keep, correct?
And again, I think it was the case that those were each of the parties' sole and separate property. I believe the only other order was that husband had taken some of wife's stolen separate, and he was ordered to return that property. But I think they were both confirmed their separate property. Husband was ordered to return property that belonged to wife he had removed, and then the land was the only community property that was divided by the court. And I guess in closing, I would just again stress that he did have his day in court. He was allowed to appear. He was allowed to give testimony. It's just his testimony wasn't persuasive. At no point did he engage in disclosure. At no point did he engage in respond to discovery. He had multiple opportunities to file a response, and as I said, he was represented by counsel this entire time, which I think makes it even more surprising that he wouldn't have even filed the most generic of a response, or even responded to any of our motions.
Thank you, counsel.
Excuse me?
I thank you, counsel. Your
Oh,
time's
you're welcome.
up.
Thank you, Your Honor. Just to point out, if you recall, the application for default was only for legal separation, not for divorce, dissolution of marriage, and that was denied. And so I agree with the question that came forward from Judge Winthrop with regard to there was no proper notice. And I'll even point out even further, the judge actually set the default hearing before 10 days. You look at the minute entry, it says that was done on the 8th, and yet the application of August, yet the application was filed supposedly on the 30th.
July 30.
The 30th. And so that was even 9 days if you don't even count the days, the 31st. And there, so it wasn't even time to file apply, and there was no notice on how to apply, and that did put him at his heels.
Well, I do have a question. It seems evident that your client or his former counsel got notice of the request for default hearing and or status conference, right?
Correct.
And got notice of the date that the hearing was set.
Correct.
Because he in fact appeared.
He did.
Telephonically. I guess the common sense question is, wasn't he on notice then that he had to do something? He had to actually file something to interpose his position on the merits?
No, because the application that was filed originally was denied, and there was no new application, and this motion doesn't, even though there's the request for it, there is no notice saying if you don't show up, you'll be defaulted. There's no notice saying that if you do show up, you'll be defaulted. There's no notice whatsoever. When I do family law, it says you have to appear, and if you don't, you can be defaulted. All those minutes, you've probably seen those on when you review those on appeal. That was not given.
There's a reference somewhere to a proposed decree that was provided. We can't find it in the record.
I can't find one. I know of no. I have the whole file from opposing counsel. I don't have that. If there was one, I don't have it. That's why I said there was no disclosure, and maybe I'm mistaken. I have the whole file that was given to me from opposing former counsel. I don't have that.
Where did the court come up with its copy that it signed the day of the hearing?
It was presented right then on the spot for the first time. That's the whole point. It was only then. You come in and you say, here's the decree, Your Honor, sign it after testimony. And the same point, you don't have him with the opportunity to cross-examine. There was no cross-examination. There was no opportunity to defend. It was just simply to determine whether he was competent. You recognize he sent a note, an ex parte note saying, I'm unhealthy. I can't make it down there. The judge was asking questions regarding his competency. And again, she made a determination that he was. Can I go over that? Maybe not, maybe so. We didn't appeal on that, but he probably wasn't competent even at that hearing. Again, those are other issues to be dealt with if we had to deal with that. But that's what the judge was determining. Not that, did you file a response? Not, do you have the right to cross-examine? He said it's my property. That was a controverting statement. There was nothing else. No evidence whatsoever to show that this was our property, and I'm referring to community property. Nothing other than her testimony says it's not our property. Again, I understand he wasn't given the opportunity. He had no notice that she was going to make that claim, and that was the most difficult thing. Lamparella, I want to point that out. Your Honor, I believe, wrote Lamparella. And so in Lamparella, there was a mirror image. In other words, if you recall, and you know this better than me because you wrote it, but there was the decree. They had a settlement agreement. It was submitted. And everything, including pots and pans, I remember in the language. It's tough to divide pots and pans. It's expensive to divide pots and pans, and that's why you do it through mediators. But counsel usually don't do that. But they had down to everything. And in this case, it was all general, not down to anything. And I'll point out in Klein. If you remember in Klein, when the mother filed, she says, "Wait a minute, I want spousal maintenance now." In Klein, she filed an amended petition. And again, that was a question of whether there was notice, and it was substantial notice that what they're going after was additional things, and opposing counsel admitted in open court, and so there's a record that he knew about the claim for spousal maintenance.
Let me ask you a question. In looking at the language of the Rule 44, it is clear that when a party attempts to obtain a judgment by default without a hearing, there are at least two requirements. One is some certain, and two, the clerk has entered the default. But that language about entering the default, the language in B1 is, if the respondent has been defaulted for failure to appear. That matching, or that language is not contained in the section of Rule 44 that deals with entry of a default judgment once there's been a hearing. And so I had asked you earlier, and I want to come back to that, which is, if a party pursues a default judgment pursuant to a hearing, because you're not dealing with a sum certain, so there's some things that have to be sorted out by the nature of the relief, then is there a requirement that the clerk enter a default before you get to the hearing?
Yes.
And what case do you have that says that? Let's start with easy. Let's start with the context of Rule 44 in the family laws. Do you have a case that says that?
Not on top of my head, Your Honor.
Okay, well, let's go to the civil rules. Do you have a case that says that?
Not on top of my head, Your Honor.
Well, you just said yes. Give me a help.
Well,
you said yes.
I
so-
believe so. I'll say I believe so, and I can't give you
That's
my,
fair. Okay.
It just seems appropriate. My concern, though, is he didn't have the chance to defend. He didn't have a chance to know that they were making that claim, and those are the issues before us. Thank you.
Counsel, I have just a real quick question, if I can. And I've misconstrued the language of the decree more than once today, and I don't want to do that again. The issue of when the land first came up as an issue. Now, we know that the judgment, the form of judgment was presented for the first time at the hearing, correct?
That's all. That's the record, and that's all. That is the facts that my client would testify to if he had the opportunity. That is, in fact, the case.
And was there a time before that hearing that the issue of the division of that real property ever came up?
No.
All right, thank you.
All right.
Thank you, Your Honor. Thank you
counsel.
for this time. It was fun.
No. Thank you, counsel. We appreciate your arguments here this morning and the briefs you filed. We will take this matter under advisement and issue a written decision in due course.